Hi, I'm Randy Micheletti. I'm the founder of Incubate IP. It's a specialty law firm, and we specialize in intellectual property services for startup and growing clients here in the Chicagoland area. I want to talk to you today about patents, trademarks, and copyrights, kind of the three core intellectual property tools that we have to help young companies protect their technology and their branding before they launch in the marketplace. Why do we have these three different protections? Well, they do different things. So a patent will help you protect the function of your product or the look of your product or the process that you make or use the product. And that's very powerful protection. It lasts for up to 20 years. And it gives you a whole bunch of tools to stop other people from using your product or selling a knockoff of your product or a service that is like your service. Very powerful protection. Trademarks don't have anything to do with your product other than the branding or the slogans that you use to advertise those products and services in the marketplace. And so that type of protection is useful to connect your company's identity with the products and services that you sell to consumers. Copyrights, completely different but slightly overlapping with trademarks, and that helps you protect the creative elements of your creation. So whether it's a sales sheet or if it's the artwork that is on your product packaging or the artwork on your sales sheet, all of those things can be protected by a copyright. So first thing you should know is they share some common features, and that is you need to ask the government for permission to have those rights. So it involves filing and arguing with the government or a government representative to get you those rights. You can do that yourself, but you're probably much better off finding an expert in that area to help you get through the process faster and cheaper. Also, they're all limited by national boundaries, so your U.S. trademark, your U.S. patent, your U.S. copyright isn't going to help you at all in any other country. So if your business is going to be active in other countries outside the U.S., make sure your intellectual property attorney knows that and can help you get the right protections outside of the United States. When do you get these protections? It depends, and that's a non-answer, I know, but it's the truth. So patents, the best time to do that, and really the only time to do that, is before you launch in the marketplace. Anytime you've already sold or offered to sell your product or service in the marketplace, it's already too late to get your patent protection. So make sure you file for that protection before you even offer to sell or show your product or your service in the marketplace. Copyrights. Same thing, doesn't matter too much other than you have to have already created it. So if the artwork is still in your head, if the sales sheet information is still in your head, if the write-up for your ad is still in your head, it's too early to file for copyright protection. But as soon as you put that down, even in draft form, as a piece of work product, it's okay to go ahead and file for that copyright protection. Trademarks, it's actually easier and cheaper to wait until you've started to brand your products and services in the marketplace. However, there's some risk attached there. So most startup companies end up filing for trademark protection before they launch in the marketplace. Slightly more expensive, a little more complicated, but an expert trademark attorney can help you navigate that system and make it seamless and painless for you. Bottom line, check in early and often with a patent, trademark, or copyright attorney as you develop your products and services, especially before you launch in the marketplace. We're happy to help you here at Incubate IP, and you can reach us at 312-600-5412. Thanks.